Okay, well, thank you everyone for joining us today. And we're very excited to dive into an exciting, important topic for homeowners associations. Today, we'll be getting into great detail with some great experts for the 2024 legal update for homeowners associations specifically. Again, there may be people on the call today that are either working or representing boards for condos associations. It's still going to be, an educational session for you, but just keep in mind this will be HOA Florida Statute 720 focus. And knowing that, I think we'll get the most out of the call for everyone today. We'll just do a brief introduction of who we have on the call as panelists. Lisa Magill, who's a board certified condominium and planned development law attorney, also a fellow for the College of Community Association Lawyers with Kaye Bender Rembaum. We're very happy to have Lisa. She's also serving on the CAI Florida Legislative Alliance for many years, which has, in my opinion, the closest pulse of all the new pending legislation, possible legislation, and legislation that does actually become law in Tallahassee related to both HOAs and condominiums. So we're so happy to have Lisa today. We also have Doug Weinstein, who is our Senior Vice President of Operations. Doug comes to the call and also with us at AKAM with a wealth of experience, 30 years in property management between New York and also here in AKAM Southeast in the Florida market. My name is David Ward. I'm the Director of Business Development here in AKAM Southeast, and I do focus on the Miami-Dade and Broward County markets. Again, we're happy that you joined us today, and we're going to dive right into the real meat of what just happened in this legislative session. So Lisa, welcome. And please tell us if we can unpack all that happened in this last legislative session regarding HOAs.
Well, first I want to thank you, and I want to thank AKAM for inviting me to present this information. The reason that we are not doing a complete legal update, including all the laws that passed this legislative session, is because there's so much to cover that it would be impossible to really delve into any details in an hour if you wanted to cover all of it. So for the 2024 HOA, the reason I suggested we handle the HOA first is because when we were planning this, the HOA laws were already signed and are scheduled to become effective as of July 1, with the exception of one that's already effective. But now, this last weekend, the governor did sign the major bill affecting condominium associations. So that will come into effect in July 1 as well, and we're ready to discuss that too in another session. But HOA leaders, there's a lot of information for HOA leaders they need to know. And for you CAMs out there, there's a lot of new requirements that may be considered a little bit onerous. So first, let me talk about the two minor bills. I call them minor bills. One was 293 regarding hurricane protection. And for condominium associations for a long time have been required to adopt hurricane protection specifications. What kind of shutters are you allowed? What color are they? What's the mode of operation? For HOAs, there's a whole lot of other issues you want to take into consideration when you adopt these hurricane protection specifications. The statute specifically says roofs, what kind of shutters, roll down, impact rated windows and doors, the polycarbonate panels. But think about things like reinforced garage doors, erosion controls, generators, even fuel storage tanks, and there's all other kinds of hurricane protection you may want to take into consideration when you develop your specifications and your architectural guidelines for like flood control measures and the like. I talk about the generator and fuel storage tanks. There's another bill I'm going to talk about in just a second that also impacts that particular issue. The other minor bill this session, which is already in effect, that you don't have to wait until July 1, 2024, is HB 59, and that's regarding the HOA rules and covenants. What this says is that all you HOAs out there, you have to distribute, regardless of how many times you've done it before, you have to distribute all the rules and all the covenants to all owners by October 1, 2024. So if you haven't obtained consent to use electronic notice, email notice, now's a really good time to do so, because if you're in a large community, think about all the labor and cost associated with duplicating all those materials and then distributing it all by mail. To the extent that you can use electronic mail, that of course would be much preferable, much less expensive, faster, and easier for people to even handle. What really changed on this, though, is that in connection with sales, the obligation was always on the part of the seller to provide the buyer with the HOA documents. And the buyer can therefore, if they chose to read the documents, they could decide whether or not the community was suitable for them. Now the onus is on the association to furnish the buyer with the documents. Well, how do you do that? Some HOAs don't even have transfer approval procedures. They don't have a screening process. You don't have an interview. You may find out about the sale when there's somebody wants to schedule a moving van to come to the community, or otherwise, make that exchange. So it could be a little bit more cumbersome for your HOAs, but once you find out that there is a new owner, and you obviously are going to be contacted because they need to make arrangements to pay the monthly or quarterly assessments, you need to provide them with a copy of the rules and the covenants. I suggest and a full set of governing documents. When I say full set of governing documents, that means the declaration back from the beginning, along with the articles of incorporation, bylaws, rules, and policies, and any amendments that have been made over the years. Some of the associations out there are very proactive, and they've either amended and restated and updated or consolidated those documents. That's all well and good. And for the benefit of the owner, it's probably easier for them to review an amended and restated document. It's one document as opposed to all these different pieces of paper. But if somebody asks for the full set includes all those amendments as they've been adopted over the years. And distribute changes to your rules and covenants. It's gone back and forth in the statute a bunch of times. It first said, well, at one point, the statute said that you'd have to distribute a copy of the recorded amendment after you amended something. And at that point, you had to distribute it by mail. They didn't even allow electronic mail. Then the law changed to say, okay, well, if you've already distributed the amendment because people had to vote on the amendment, so they have the text of the amendment, you didn't have to redistribute the recorded amendment if there were no changes, which there wouldn't be. You'd only need to notify your owners of the recording information for the amendment. Now, go back again. You're now distributing the rules and the covenants as they are amended from time to time. So again, to the extent that you can utilize that electronic mail, it's going to make your life a whole lot easier. So here are two lesser known bills. They weren't really on our radar because they're part of larger bills that pertain to other issues. And the one I want to talk about most is that HB 1645, prohibited clauses in association documents. So the HOA governing documents and your rules and regulations may not prohibit the use of fuel sources that are provided from the public utilities or the natural gas utilities, or even liquefied petroleum and gas dealers. And I think the reason for this is really related back to 293, the hurricane protection, because in that bill, you're tasking the HOAs with creating hurricane protection rules. What are we going to allow in our community? What's the process for installing it? Is there an approval process? What do you have to submit the actual materials or permits and what have you? And one of the things that were mentioned was a fixed generator. So when you have a fixed generator, you need a fuel source for the generator. Now, in my neighborhood, I'm happen to be lucky. I have gas service in my neighborhood, and it was already plumbed to my house, so it's fantastic. Half of my appliances are on gas. Of course, my grill is operated with the gas, and I have no worries. But in some neighborhoods, you don't have gas service. So in order to obtain a fuel source for a fixed generator, they may have to have a storage tank, and they usually put those in the ground underneath the front or the back lawn or something along those lines. Somebody in my neighborhood, I don't know why they did this, but they actually they wanted to use liquid petroleum instead of the actual natural gas. So they have a tank in their yard and you can't even see it. I mean, there's a valve, maybe 3 or 4 inches round, the circumference of which is probably 4 or 5 inches. And it's in the lawn. And when the grass is freshly mowed, maybe you can see it. And the day after the lawn is mowed, you can't even see it because, of course, the lawn conceals everything. But these are things to think about, because what if your HOA has common irrigation systems? How are people going to dig an area for a storage tank and not interfere with the system? Maybe your HOA handles the landscape maintenance on its own. So those are all things for you to take into account when you're developing these hurricane protection specifications. And the other issue is on Marketable Record Title Act. That's MRTA, MRTA. There's a picayune requirement in the act, and it also is enforced by the Department of Financial Services, now the Department of Commerce, that said you have to submit all of your materials to the government within 60 days of the date that you receive the majority vote. So with written consents, you may have 100 owners out there, and the consents come in one at a time, 5 at a time, whether they're emailed, whether they're mailed, you're checking the mail. You have to be cognizant of when you get that 51st written consent, even if you're waiting for other people to vote, because your 60 days starts on the date that you receive that 51st or that majority actual vote, as opposed to your waiting period for people to submit their votes. It's a little picayune requirement. It actually was utilized against me. I was not aware that the DFS interpreted the law to say from the actual majority. I waited until I got all the votes that I thought that people were going to submit, and then I submitted within 60 days of that. It might have been like 52 days of the date that of the closing period for the voting in that particular community. But of course, it was more than 60 days. I think it was like 61 days from the date they received the majority vote. So the DFS kicked it back to me. We had to redo the vote. It was a small community, so it wasn't that big of a deal, but I was embarrassed by it. I didn't know how they interpreted it. And that's maybe why they changed the statute to make it far more clear, so other people don't fall into that trap. Now, the biggest bill for HOAs is this HB 1203. We're not going to talk about every single thing in there, but we are going to talk about some of the meat and potatoes that really impact you as community leaders and impact you CAMs out there, because there's some new education requirements and some obligations that you have to attend to. Let's move on. So let's talk about mandatory education. No longer will you be able to just sign that form and say, hey, I've read everything and I'm good to go. No, not good anymore. Not happening. Now you have to have an initial education certificate, and the board certification education has to include financial operations, financial transparency, record keeping, the fining process, and meeting notice requirements. But there's more. Not only do you have that initial board certification certificate that you're so proudly display on your refrigerator, and you give a copy to your association secretary or whoever maintains your records, you have to do 4 hours of education annually if you're a HOA leader of a community that has less than 2,500 parcels. So for people that are on the call today, it's probably no big deal for you, because you are obviously concerned about the operation of your community. You want to stay abreast of all the changes in the laws. You want to make sure that you are able to fulfill your fiduciary responsibilities, and you do that by attending voluntary education sessions just like today. So 4 hours over a year, no big deal. For those HOA directors that govern communities with 2,500 or more homes, as 8 hours of education annually for them. That's required.
Lisa,
Okay,
So
just
so
could you go into a little bit on this particular with the mandatory education? Because we've gotten a lot of questions from existing HOA board members is, I've taken my required course before this became into effect. Now this is going to come into effect July 1. How does that affect my current status?
right. Well, you know what? We don't know. The DBPR is supposed to approve these classes. So I don't know if DBR is going to require all the existing classes to be recertified. I can tell you that all the board certifications that I'm aware of, and especially those in the legal field, they always include financial operations, record keeping, the fining process, and meeting notice requirements. They include actually more than that. They include all kinds of alternative dispute resolution. It includes rulemaking process. It includes the election process. So it includes sometimes insurance. So it's unknown at this point whether or not you existing directors will need to take another class. They do give you until I think it's June of 2025 to obtain that initial certification if you if it is necessary for you to get that new certification. That's the best that I can answer now. There's a lot of questions that remain unanswered because DBPR has to get its act in gear, and the laws are not even effective until July 1. So their funding may not come into play until July 1, which means that they have to beef up their staffing, they have to create all these new policies, and I think it probably could be a little bit tumultuous over there. But that I have reached out to DBPR to ask those questions, and I'm not sure if even the representatives there have the official answers yet.
well, Lisa, also quickly, this change, just to clarify for everyone listening, that option to simply sign a form and certify, I've read all my declaration, I read all my covenants, I understand my responsibilities, and sign the form, I'm certified, that option's no longer available. And it used to be a 2-hour requirement as the other option, which is now 4 hours. So is that accurate? And does Kaye Bender yet have an idea of how that might actually be delivered, or not just yet?
We're not exactly sure yet. I think in the past we had both condo classes that were devoted to condominiums, classes devoted to cooperatives, classes devoted to HOAs, and we also did combined classes. Well, with the requirements being what they are, we'll probably it's hard for me to say at this point, but it's probably more likely that the classes will be divided as opposed to being combined. Because, I mean, how long can you physically pay attention to an educational presentation like this, number one? Number two, I don't see anything in the law that requires it to all be at one time. So when you talk about 8 hours of education annually, that doesn't mean you have to sit in a room in front of your computer from 9 through 5 p.m., 9 a.m. through 5 p.m. So that all needs to be addressed by the DBPR. And the course materials, if they need to be recertified, need to be recertified by DBPR. I have had a lot of those questions. For the fiduciary duties, if you've been on your HOA board, and for you CAMs out there, this has always kind of been the rule. Now it's actually stated in the statute that the standards for directors that are in the Not-for-Profit Corporate Act apply to you as HOA directors. So if you've been on your board, you've probably heard your own attorney say this a dozen times. You have to act in good faith, with the care of a reasonably prudent person, and in a manner to be believed in the best interest of the corporation. That goes without saying. So sometimes the best interest of the corporation is adverse to your own personal interest, but that's why you're serving as a fiduciary, as a board member, and you're responsible for the operation of this corporate entity that has all the duties and responsibilities that's laid out in the Declaration of Covenants and Restrictions. Websites. So record keeping. I mean, you can see that the education requirements include record keeping. And I can tell you from the division standpoint, for condos and cooperatives, and they don't really have jurisdiction over HOAs, record keeping is the most often complained of issue. People complain that they are failing to, they're not being allowed to access records, or when they go access records, they're getting all kinds of hassles, or the records are so unorganized that it's impossible for them to make heads or tails out of the records. And you're going to see a lot of things with record keeping. But one of the issues that were, or one of the requirements for this year, is that now HOAs with 100 or more parcels are now going to be required to have a website. And in my opinion, having a website is like a godsend, because if you have hours and hours devoted with your, whether it's your staff, whether it's your volunteer board members, whether it's your management team, hours and hours devoted to finding the records, making appointments, sitting there, watching people as they look at records, it really can be just a massive waste of time. And it can create a lot of strife, because if you have volunteer board members sitting there, they may get into a little bit of a tete-a-tete, with the people that are actually conducting the inspection. So to the extent that you can get all these records up on a website, and someone says, hey, I want to see the management contract. Oh, it's on the website. Just go to the tab that says contracts. Or I want to see the financials from last month. Go on the website. You have to log in because that's protected information, and click on the tab that says financials. Great. I think it's wonderful. You have until January 1, 2025 to get all those records up there, and I can furnish anybody a list if they so desire. Most of the official records are going to be posted on your website.
One of the things
Some
just on
other-
the website to make a note of, with all the documents that now have to be posted, and this is just a technical issue, if for those associations who are going to have to do a website from scratch, there are a number, obviously, of providers out there. But one of the things to look for is that when you enter into an agreement for an outside provider, make sure they have the capability to upload the amount of documents and the bandwidth to do that.
I'm so glad that you said that, because another issue that you must take into consideration when you're creating these websites is ownership of the data that's uploaded. It could be burdensome, it could be a little bit cumbersome to get all the documents that you need uploaded to the site. Could you imagine if you get into a dispute with your website provider and they just shut it down and now you have to start all over? No, you want something in your contract, with whether it's with your management company or you're going to an outside provider, that says, hey, listen, if there's ever a termination for any reason, could be, bad reason or a good reason or no reason, that all of the data is going to be furnished to you in electronic format, so that you can go to your new provider and hit a bunch of clicks. I don't really know how to do it because I've never done it, but you want to make it easy for you. You don't have to recreate the wheel at that point. Communities with 1,000 homes or 1,000 parcels are going to have to prepare an annual audit every year. Well, at least every other year, because with all communities that you prepare, that financial report at the end of the year is based upon your amount of income. If you have 1,000 units, it's audit regardless of the amount of annual income. And you're not allowed to reduce the level of financial reporting anymore for consecutive years. So every other year, you're going to have to do the report that your level of income commands.
Lisa, just a quick question that we already have in the chat that's very much related to the websites that we were just talking about, and also the requirement to send to residents. I have a good question. Person asks, if the documents are already on the HOA website, already ready, available, have been for quite some time, is it still required to physically send them out, either by electronic or physical copy, to all the residents? Or is it acceptable to say just email everyone before October 1st and notify all the owners where they can access the documents?
Well, certainly if you do have permission to use email, you're able to do that. And I'd have to recheck the statute, because I do believe that there's language in there that says that if you have this documentation readily available on a portal or a website, and you can lead people to that site, that would be sufficient, so that you could avoid some of the mailing and duplication costs. I do need to verify that, though. But you CAMs out there, not only do HOA directors need to be educated, you CAMs out there have to have some additional education if you are managing HOA communities. So it's 5 hours of education specific to HOAs every 2 years, and at least 3 of the 5 hours must focus on the record keeping. So you're going to see that record keeping thing, hammered at you over and over and over again. Additionally, the CAMs, you're going to have to attend at least 1 meeting in person per year. Furnish the HOA owners, your constituent unit owners, with contact information for the person that's responsible for that community in your company. So that could be either the CAM, it could be an administrative person, but they need to have the name and the contact information for that person. You have to provide owners a summary of the duties and responsibilities and provide them with a copy of the management contract upon request. Now, the management contract was always an official record that would be subject to inspection, but this is just another level to show that we want the CAMs to really be transparent with our owners. Hopefully that's not going to be too onerous for you all as CAMs. I mean, you already take as much education as you do. Here's where we're going to get into things that may cause a little bit of trepidation among the HOA leaders, HOA members, and of course, the CAMs that are managing these communities. And that's the changes to the architectural control issues. So one of the big changes is that if there's an interior, if somebody wants to change something in the inside of their home that's not visible from the outside or the exterior, that the HOA really does not have authority to exercise architectural control. Now, that definitely makes sense if you have detached houses, but people have brought to my attention, what if you do have connected houses? Townhouses or villas or other types of communities that are connected. I mean, obviously, I do not believe that this would impact the party wall, because the party wall is a shared wall, and most of the declarations will have specific provisions when it comes to that party wall, what can be done, what can't be done, who's responsible for damages and the repair and the maintenance thereof. But other interior changes like the installation of central AC or making other changes that you can't see, that really are just outside of your control. Here's a big one. Hopefully the people on the call today, they have written published guidelines or some kind of specifications for their architectural control. Basically saying, we don't have that, or we don't like that, or it's never been done that way. I think it's going to be hard to rely upon those types of answers. So this law requires you, whether it's the board or the Architectural Control Committee, to specify why they are denying a particular application for exterior change or improvement, and pinpoint the rule or the guideline that authorizes them to deny that particular improvement. So if your documents have a 5-foot setback and somebody submits an application to put a fence on the property boundary line, the perimeter, well, you're going to reject the application and you're going to say, we're rejecting the application because it does not comply with the 5-foot setback that's in Article 2, Section 3 of our guidelines, or Article 2, Section 3 of our declaration. You'll need to be able to do that with other types of improvements. Pool installations, major modifications to the landscape, if people want to make exterior changes, additions to their homes, or change the type of garage door, or change the driveway, or what have you, you really need to try to think about what your standards are for your community and what will be harmonious with the look and the feel of the community in light of these requirements and also the hurricane protection specifications. The HOA, you can't prohibit. Last year, there was a law saying you couldn't prohibit artificial turf or boats or other items in the backyard if they were not visible from an adjacent parcel or from the front of the parcel. Now that's been extended to include flags and vegetable gardens and clotheslines. And if they're not visible from the front, an adjacent parcel, an adjacent common area, or a community golf course. So there's still questions on this. I mean, what happens if you have a big old fence so you can't see the stuff, the vegetable garden in somebody's backyard, but the next door neighbor is a 2-story house, and from their second floor, they can see the vegetable garden. Does that count? Does that not count? We really, we really don't have good answers to those questions, but it's something for you to take into consideration and be cognizant of when you are developing those specifications. And there was a little bit of consternation last year about this. I haven't had any circumstances with my clients where they have run afoul of this or it's where it's been a problem. But I do know that in Southwest Florida, it's been a little bit more of a problem than it has been here.
Lisa, on that last question, we do have a little bit of a Q&A in here that's related. Does this mean regarding, artificial turf, boats, flags, etc.? Can an HOA limit a specific type of item that is visible, such, on the front, such as a basketball hoop?
Oh, well, I mean, if your governing documents permit you to do so, definitely. I mean, that is what architectural control is all about. So if you want to specify in if you have the authority to do so, and you want to specify in your guidelines, no basketball hoops, no permanent play structures in the front. I mean, many communities have restrictions against permanent play structures in the backyard, and a lot of those play structures are higher than 6 feet, so they would be visible from an adjacent parcel or the backyard or what have you. But yeah, that's exactly why you want architectural control. If you want to put up people want to put up awnings, they want to eliminate the yard itself and make more of a parking area. Those are all things that HOAs really regulate because they want to maintain the aesthetic nature of the community. I just wanted to give a little bit of a refresher on this too, because back, I think it was 2007, it was kind of a while ago, there was this provision entered into the statutes called architectural control. And it says that the HOA or the Architectural Control Committee is only allowed to review plans and specifications or enforce guidelines to the extent that it's specifically stated or reasonably inferred from the Declaration of Covenants or other published guidelines and standards. So since then, I know that my firm and many other firms have really encouraged the HOAs to make sure that their architectural guidelines are complete, that they look at them every year or 2 years to make sure that they're still appropriate for the neighborhood. I mean, the styles change, people change, things change, and that they have been published, that they've actually been distributed to the owners. The owners know what they're allowed to have and what they're not allowed to have. There are plenty of cases that go through the court systems when it comes to changes or exterior changes that owners desire to make, flying flags, flag poles, and the like, installation of fountains, pool installations, all of those need to be addressed in your architectural guidelines. But I'm going to move forward because here's another issue that I think that many of our attendees may have some questions about. I wonder if the questions are coming in. I don't see the chat right now. Parking restrictions. So vehicle and parking restrictions. When this law becomes effective, that's July 1 of this year, the HOAs are not going to be allowed to prohibit owners from parking their personal vehicles in the driveway of the parcel. It specifically says pickup trucks. Now, pickup trucks are regular passenger vehicles. I mean, some of these pickup trucks, that they cost over $100,000. They have more bells and whistles than any other vehicle known to man, and they're regularly accepted. But back in the day, back in the 70s, everyone thought about pickup trucks. Well, I didn't. I was a child. Didn't really think about pickup trucks back then, but they thought of them as work vehicles or unattractive, and may have wanted to prohibit them from being parked in driveways or in any way that's exterior. This goes one step further because most communities have changed the rules to allow pickup trucks regardless, because that's what people drive. This goes a little bit further. It says you cannot prohibit or you cannot stop people from parking their work vehicles on their parcel. So a work vehicle, I think about Truly Nolan. You know, I have a car that has ears and a tail and the whiskers and what have you, and it says Truly Nolan with a big old phone number on the side. And many associations, I would venture to say most associations, have rules that say those type of vehicles, we call them commercial vehicles because they have commercial signage on them or commercial advertising on them. And now you're no longer able to do that. So the contractor vehicle, same is true with first responder vehicles, law enforcement vehicles. In the past, I did have some communities that had problems with first responder vehicles, but in my experience lately, in the last, at least the last 10 years, most of the communities like having a law enforcement presence on property, so they don't have any rules prohibiting people from bringing law enforcement vehicles onto the property, but you can't not prohibit those. And you wouldn't. It's really, I think the issue is going to be about the branded vehicles, the Sally, not the Sally Mae, who's the car, the pink car with the makeup that they sell.
Mary Kay.
Mary Kay vehicle.
Usually a Cadillac, I believe.
Well, or any roofing truck, any truck that has a roofing sign on the side or landscaping sign on the side. Those are the regular vehicle for the owner. That may be their only vehicle. They're allowed to park it on property. It also says you can't prohibit people from from operating legal vehicles. So I put in there, you can't prohibit street legal motorcycles or mopeds or golf carts. Most communities do allow them if they're street legal, meaning they have license plates and they have all of the safety equipment that is required for street legal vehicles. And some communities even allow, against my better judgment, they even allow unlicensed vehicles to operate, like golf carts without license plates if they have private roads. That's something for every HOA to think about, whether or not they want to allow it or not. What kind of comments did we get on this, David? I'm sure something came in.
Well, I'm going through it quite a bit. There's actually questions about interior changes. So I'm going to keep looking, but yeah, at the end, there might be some parking questions as well.
Yeah, I had a case where people had limos parked in their driveway, and they had a big driveway and they could fit all the limos, but other people in the neighborhood got really upset about all the limos, and those were actually classified as livery vehicles. So we called them commercial and then ultimately forced the owner to get rid of them. And another situation in a property that I represented where the owner was a car dealer. He was one of those luxury used car dealers, and he would have several vehicles. He was a broker basically, and he'd have several vehicles. So his entire driveway, more than the driveway. I mean, really, the driveway and the front lawn and the side of the house were filled up with these luxury, beautiful vehicles, but it had a messy appearance, and people really took umbrage with it. So ultimately, the association was able to compel them to comply with the requirements of their governing documents. But I mean, you see this all the time.
Lisa, we do have two quick parking questions. Obviously, every association in their covenants are going to be different. That said, the person's asking, what would be the dominant factor regarding this new law change versus, say, city ordinances or something local? I think associations are often, if not always, you're the attorney, Lisa, considered private property, but some of that street and roads might have to be maintained by the city. So, how does a city ordinance about not parking commercial vehicles on a residential zone maybe come into play with this new law?
That's a good question. Now, when I say private property, some associations have private roads. So they're responsible for maintaining the roads. They have full control over use and utility of the roads. They have full control over parking on those roads. Some associations have public streets, and they are subject to the municipal guidelines for parking. This particular law exempts commercial vehicles, but it uses a definition. It uses a specific portion of the statute that talks about commercial vehicles that are 26,000 pounds. So me, not knowing anything about cars, vehicles, what have you, I went to go look up what kind of vehicle has a gross vehicle weight of 26,000 pounds. And I found this graphic on the internet where the cars that we think of in class 2, the minivan, cargo van, full-size pickup van, that's 10,000 pounds. But what we think of as commercial, I think of as commercial vehicles, a box truck. I mean, that to me, it looks like a commercial vehicle. It only goes up to 14,000 pounds. If you look at this chart, and if this chart is accurate, which, you know, I saw several of them, that the commercial vehicle, 26,000 pounds is a class 7 vehicle. That's like a truck or a tractor trailer or a bus. So you know what? These laws are adopted based upon the constituent concerns. You have a legislator, you have a representative for your neighborhood, you have a state senator that governs your neighborhood, and they heard issues about prohibitions that really constrained homeowners, made it really difficult for certain homeowners to live in their neighborhoods. Well, again, the fallout hasn't occurred yet. Maybe this needs to be revisited, and maybe they need to change the definition from that 26,000 pound vehicle down to the 14,000 pound vehicle, or make it another definition of commercial vehicle so that it would be more palatable to our HOAs. Another issue I've heard, and I don't know if anyone's raised it, and I'm surprised to hear it from board members, unit owners, is that there's a notion called Kaufman language. The federal or the US Constitution and our Florida Constitution prohibits the government from adopting laws that override or circumvent private contracts. And these declarations of covenants that are recorded against the property are considered contracts. So the law that prohibits the impairment of contracts doesn't apply if the legal issue is of a compelling public purpose. Think about discrimination laws. You know, back in the day, many of the Declaration and Covenants would have racial restrictions or religious restrictions. You know, we don't see that now. Hopefully nobody has that now. My former employer used to have a sign, because he thought it was hysterical, where the Declaration of Covenants specifically prohibited anyone that was born north of the Mason-Dixon line from living in the community. Weird restriction, but it was there and it was enforceable until a certain period of time. Now, those racial restrictions nobody would consider enforcing, but things like this, substantive rights, your right to govern the look and appearance and the use of your community, that's a substantive right. And there may be challenges to some of these laws when it comes to the architectural control, when it comes to the vehicle restrictions, over whether the law went too far, whether the law really infringed upon these private contracts.
Well, Lisa, your chart is excellent. We do have a question specifically related to this chart, and just to help everyone understand, I think this is great. Can an association deny, still with this new law, a parking box trucks on site? Or, you know, would that have to be maybe specified as an amendment in the docs, or would that not be allowed as it's currently being passed?
Well, I mean, what this law says is that if I drive a box truck as my regular vehicle, and a box truck with even that has signage on the side, I'm allowed to park it on my parcel, on my driveway. Now, most of these trucks will not fit wholly within the driveway. So that's where I see the ability for HOAs to maintain a little control. I don't know if a box truck would fit in my driveway.
Now, you mentioned, Lisa, just a moment ago, and you said that language, you know, as their personal vehicle or as their vehicle. I mean, could you see a lot of debate going back and forth? How do we make sure that that's the case? Or what sort of thing can we ask a resident to prove, let's say? in that regard.
Well, one of my colleagues already had a situation where a homeowner claimed that his RV was his personal vehicle. So we joked about it a little bit. I mean, I said, unless that guy goes to work every single day with that RV, that ain't no personal vehicle. So we have to blend some reason into our interpretation of these laws, I think. And sometimes you need to think like a sensible person as opposed to doing whatever you can to try to circumvent your HOA's requirements. Does that answer your question?
Yeah, I'm just thinking now, what if your next door neighbor's a funeral director? But anyway, I digress.
Yeah, exactly, because that's not, I don't know how many funeral directors use their hearse as their sole vehicle. It's one thing if you're the truly Nolan guy and you want to use that as your sole vehicle. It's another thing to be driving around in a hearse, but the Ghostbusters did it and they had a good time. So more power to you. Finding provisions have also changed. You can't fine for leaving garbage cans out 24 hours before or after garbage day. So if your garbage day is Tuesday, people leave it out, put it out on Monday, pick it up on Wednesday. That's compliant. Now, since I've actually been doing these webinars, I've had people email me and say that they have garbage day Monday, Wednesday, and Friday. Well, first of all, who's lucky to have garbage, pick up 3 times a week? That's fabulous. I would love it. But that would mean it's basically the entire week, because if you're allowed to put it out on Sunday for Monday, and you're allowed to put it out Tuesday for Wednesday, and you're allowed to put it out Thursday for Friday, and you don't have to pick it up until Saturday from the Friday pickup, then you have garbage all, the entire week, the garbage cans are out. Now, again, let's think about some ration or reason into the development of the law. The people are going to have to bring their garbage cans in to put more garbage in it for them to bring it back out, unless they're always going to walk to the end of the driveway to throw out their garbage. And you would hope, although sometimes this hope is ill-fated, that people that live in community associations want to respect their neighbors a little bit so that they aren't flouting those rules solely for the purposes of trying to make other people irate or to try to make their directors go crazy. But it happens. I'm sure you have experience with that. Same thing is true with holiday decorations. But a lot of places have rules. You have to take down your holiday decorations 10 days after the holiday, the lights or what have you. You still can't fine for the lights unless you send them a written notice saying, hey, the holiday was 3 weeks ago. You were supposed to get rid of your lights by 10 days from the date of the holiday. We're going to give you 7 days. If you don't remove them within the 7 days, we're going to start the fining process, and then you can go forward with that fine. Other changes to the fining procedures. The way I read this law, it looks to me that you have to have a hearing regardless of whether the owner requests a hearing or the person sought to be fined requests a hearing. The reason I say that, it says the hearing has to be held within 90 days of notice of the intent to fine. And it also says that you have to furnish the person sought to be fined with a copy of the written committee finding within 7 days of the hearing. Well, if there is no hearing, we're going to have to change our finding procedures or rules and regulations for a lot of clients, because typically you would only hold a hearing if somebody said, okay, I want a hearing. Yeah, you can't find me. I didn't do that wrong. So I want to be heard. And then you would set up a date and a time for the fining hearing, and you provide 14 days notice so that they can come and they can bring, their attorney, or they could bring, whatever witnesses they wanted to, and they could plead their case. Here, if you have to furnish them with written committee findings, I believe as of now that you have to go forward with a hearing. If the person doesn't show up, no problem. The board will present its case to the fining committee. The fining committee will make its decision based upon the information from the management or from the board, and the fine will be confirmed because you don't have any opposing action. But you can't collect the fine if they cure the violation before the hearing or before the finding, notice before the actual hearing. And that, I don't have either good, bad, or indifferent to say about that, because really what you want here in all kinds of community associations is you want compliance. So if your letter saying, hey, you're going to go up before the fining committee on August 10 does the trick, you've won. You've actually effectuated the change that you were looking for. So you should feel good about that. And you know how hard it is to collect these fines. In an HOA, you still can have that lien authority if it's over $1,000 and the governing documents so provide. But if you have those $300 fines against the account, 200 for this, 100 for that, again, you'd have to go to small claims court under most circumstances to try to collect the fine, and your costs associated with trying to collect the fine are going to exceed your fine. So the fine is really to be utilized as a deterrent more than a revenue generating mechanism. I wouldn't think of it as a revenue generating mechanism under any circumstances. So that's an overview of the statutory changes. Now, there were other changes, of course, minuscule supplements to the items that I talked about, but I wanted to give a nice overview so that you CAMs out there know what you have to do with respect to your education requirements. You HOA directors out there know what you need to do to the extent that we have direction from the DBPR on your education requirements, and just to be cognizant of that website, your record inspection issues. There's also provisions in the law that create criminal penalties for voter fraud or interfering with the vote of owners, particularly when it comes to the election of directors. And there are criminal penalties for really onerous actions when it comes to records. So if you're refusing to maintain records, or you're manipulating records to try to avoid or escape liability or escape detection that you've done something wrong, there's going to be criminal penalties associated with that. None of the people that are listening to us today are going to be in that classification. Well, criminal penalties associated with kickbacks too. I mean, I think everyone realizes that a kickback is illegal. Detecting it or obtaining the evidence of it is the harder part, in my opinion. So that being said, I'd love to hear your input as to what the changes are going to entail for your communities, and address some of the questions that have come in.
Sure. I think we have one question that is interesting, is a definition question. The question is revitalization of documents the same as preservation of documents?
It's not. So I talked about that marketable record title law. Basically, and this is very, very simplified, but basically what that says is that the restrictions recorded against a property can expire if not preserved within 30 years, or if deeds do not contain actual references to that declaration of restrictions. That's an very, very old law, and it was a good reason for the law, because you could have like really old restrictions against properties and you have no way to eliminate them, and it would encumber the property and eliminate certain uses. So the preservation process is really easy. You do that before the 30 years, and it's a board vote. You do a couple of notices, you record something. It's simple, doesn't require a lot of effort on the part of the board. It does not costly at all. If you've been past the 30 years and your documents have expired, that's when you go through the revitalization process. And that can be really cumbersome because it requires the approval of a majority of the members. You got those 1,000-unit communities out there. Think about trying to get 500 people to sign off on something. They may not even object to it, but it's just getting 500 people to participate in a vote is an obstacle. And then you have to submit it to the Department of Commerce, and they, exercise a whole bunch of picayune requirements sometimes. as to what you've done, what you didn't do, what the forms are, how it was distributed, the timing and the like. Have you included all amendments from 1973, or did you skip something and that kind of a thing. So yeah, if you're out there and you take a look at your documents, see if they're like 25 years old. If they're 25 years old or so, talk to your counsel who should have already alerted you to it so that you could just do the preservation, get it done, get it recorded, and save yourself a lot of time and expense.
Right. And the next question is, a board member who is not currently certified has until 7/1/24 or 7/1/25 to become certified.
No, I think they have until June of 25. I don't recall the date right off, but I really think that they have a long period of time to become certified.
Okay. If a homeowner does not give email access to management, can they get charged for an updated copy of rules and amendments?
For a physical copy.
Right, no, the documents under 59 need to be distributed. And I do not believe that there's a cost associated with that distribution, but that's something that I will verify.
Okay.
We have an interesting question here, Lisa. This may or may not be related to the new legislation, but basically an owner is asking, or a participant is asking, if an owner applies for an ARC, and that particular, modification or request is approved, but say it's against their covenants, can a neighbor owner that notices this file some sort of appeal and challenge the ARC committee's approval?
Yeah, appeal rights are very document dependent. I mean, that would be an internal procedure, but yeah, HOAs are sued all the time for approving architectural modifications that were not permitted by the governing documents, and how they pan out is different in all different cases. In some cases, the court would rule that the homeowner relied upon the ACC approval, and they spent all that money, and therefore the homeowner can't be compelled to remove everything they've already done because they've spent all that money. In other cases, I've seen the HOA bear responsibility for the financial cost associated with removing the improvement if the court does find that it's in violation of the governing documents, because the HOA was the one that duped that homeowner into that sense of security. So, and in other cases, I've seen where it depends on the actual nature of the modification, but if the modification is, a lot of times the HOA documents will say that the board can grant variances. So they'll approve it as a variance and the improvement will be allowed to remain. But yeah, there's a whole myriad of concepts that could occur from mistakes on HOA approvals. And remember, on the HOA context, before you file a lawsuit, you have to ask the other side to participate in pre-suit mediation. So hopefully that would be resolved in the mediation process.
Would you have any final thoughts before we say goodbye, Lisa or Doug?
Yeah, I mean, these laws change every single year. And I applaud you for participating today to keep up to date with your obligations as community directors. I don't want to dissuade anyone from volunteering to serve on their board. It's a very, very important job. You have a lot of responsibility, and I know sometimes it's somewhat thankless, but the job does need to be done, and those careful stewards are really making what makes Florida what it is. So thank you.
Lisa, thank you, and David, thank you. And just in closing, I would add that, the last couple of years have seen an incredible amount of increased regulation or increased statutes having to do with HOAs and condominiums. And I think what's going to happen is, I don't think we've seen the end of this. I think what you're going to see is that even the laws the laws that were signed in this year may change in the next legislative session. So I think we have to look at it as something that is going to be a continuing process. as we go down the road. And, you know, we always come up and we see bills now that are called, you know, Condo 3.0 or HOA 2.0. So I think you know, you're going to see that, and what we may talk about today may be different than coming out of the legislature next year.
Definitely, good point.
Great. Thank you both so much. Thank you, Doug. Thank you, Lisa, for all your insight. And thank you, everyone, for participating. Again, we will have the replay available on our website, also YouTube channel, and look out for the slides to be sent out by Kaye Bender. Take care, everyone.
Thank you, and
Bye-bye
have a
now.
good evening, everyone.